Well, good afternoon, everyone, and welcome to 3PB's Employment and Discrimination Law Group December Case Law Update. My name is Craig Ludlow. I'm the head of 3PB's Employment and Discrimination Law Group, and I'm joined today by my colleague in Chambers, Kath Anderson, who is an employment discrimination and education law specialist, whom the Legal 500 describes as highly intelligent, thorough in her work, and is a tenacious barrister. Good afternoon to you, Kath.
Good afternoon, Craig.
How are you today?
I'm very well, thank you. And you?
Yeah, very well, thank you. Looking forward to a break.
Understandably so.
Right, so this month's update is really a follow-up to our newsletter, which was published on the 3rd of December and can be found on our 3PB website under the news section, and in which you will see lots of interesting news, articles, a recorded webinar on whistleblowing and injunctions, and our November case law update recording as well. So today, Kath and I are going to be discussing 4 recent cases, the citations for which should appear in the bottom left-hand side of your screens as we discuss them. But in case you want to fast forward the recording to get to the cases you're interested in hearing about, in order, I'll just let you know what they are as follows. So we've got Heskett and Secretary of State for Justice, and that deals with the justification defence in age discrimination cases. Simpson and Cantor Fitzgerald Europe, that deals with a recap really on whistleblowing law. Independent Workers Union of Great Britain and Secretary of State for Work and Pensions and others, which is a judicial review case arising from gig economy workers not being provided with PPE. And then finally, the case of Miron and Adecco and Whitman Laboratories Limited, and that's an EAT case involving appeals against case management decisions. So, Kath, if I can hand over to you to tell us about the first case, please.
Heskett and Secretary of State for Justice. Well, Craig, this is an important new decision from the Court of Appeal on whether the saving or avoidance of costs can amount to a legitimate aim for the purposes of an employer's justification defence in an indirect age discrimination claim.
So what's the background to that case, Kath?
Well, the respondent employer had slowed down the rate of pay progression for its employees because of austerity policies in the public sector. And this was found to affect younger employees disproportionately, as they would have to work longer than their older colleagues had to work in order to move up the pay scale. In the claimant's case, he would have had to work 23 years to get to the top of the pay band instead of 8 to 9 years. The employer's defence was that the change was required to balance the books due to budget cuts.
So how did the Court of Appeal approach the legal questions involved in the case?
Well, first, the Court of Appeal confirmed the principle in Woodcock that on the basis of the case law of the Court of Justice of the European Union, the saving or avoidance of costs will not, without more, amount to the achieving of a legitimate aim. Therefore, the essential question is whether the employer's aim in acting in the way that it acts gives rise to the discriminatory impact, whether that can fairly be described as no more than a wish to save costs. Then the Court of Appeal did point out that the distinction between what we lawyers refer to as a shorthand as costs without more and costs plus can be subtle. Right,
so are budgetary constraints costs without more or cost plus?
Well, the Court of Appeal held that the employer's need to reduce its expenditure, and specifically its staff costs, in order to balance its books, could constitute a legitimate aim for the purposes of a justification defence. In other words, it's not costs without more, quote unquote. The court accepted that it can sometimes be difficult to determine whether an employer simply wishes to reduce costs, and cases where it is in effect compelled to save costs because of an absence of means. Only the latter will be a legitimate aim. The Court of Appeal also emphasised, however, that an employer with a legitimate aim will still need to show that the measures complained of are, or were at the material time, a proportionate means of achieving that legitimate aim, having regard to their disparate impact on the group in question.
So what's the wider effect of the decision, do you think?
Well, I think on the basis of this decision going forwards, employers are likely to find it easier to show that in their cost-saving exercises, they do have a legitimate aim for the purposes of the justification defence. But I anticipate that where such justification defences are raised by employers, well, the focus of the argument will shift towards the second limb of the defence. In other words, to questions of proportionality and considerations of whatever alternative means the employer could have pursued, which would have had a less discriminatory impact. So Craig, tell us about the next case.
Yeah, so the next case I wanted to speak about is called Simpson and Cantor Fitzgerald Europe, and it's a unanimous Court of Appeal handed down on the 27th of November of this year, in which the court dismissed a claimant's appeal in a whistleblowing claim based on aggregate disclosures, or aggregated disclosures. Now, whilst not making any new law of general application as such, it does provide a useful summary and affirmation of some of the key legal principles and frequently recurring issues that crop up in this area of law, in particular aggregated disclosures. It's a 38-page judgment, so it comes with a warning. It's definitely worth reading, though, in full for anyone who practices in this area. And this recording is very much a whistle-stop tour through the judgment. But even if you haven't got time to read in full, there's an excellent article written about the case by our colleague in Chambers, Joe England, in our December newsletter, which can be found on our website in the news section.
Indeed. Remind me, Craig, what were the facts of the case?
Yeah, so the claimant worked for the respondent, which was a UK-based investment bank, for approximately 10 months between February and December 2015. He was a managing director on the emerging markets desk, and whilst he was employed there, he made allegations about a number of the respondent's trading practices, including allegations of something called front running, which is an illegal practice similar to insider dealing. As well as a range of other financial irregularities and breaches of FCA rules. He was suspended and dismissed after such allegations had been made. In his ET1, he made public interest disclosure claims under Section 47B, detriment, and Section 103A, automatic unfair dismissal. And the tribunal identified the claimant's case to be based on 37 separate alleged disclosures. Now, the ET found that none of these 37 communications, was a protected disclosure, either because they were insufficiently specific or because Mr. Simpson did not genuinely believe that the information contained in them tended to show malpractice at the respondent, and that to say that the principal reason for Mr. Simpson's dismissal was that he had made protected disclosures would be, and I quote, utterly fanciful. It found that Mr. Simpson's distrustful and obstructive behaviour had made it utterly impossible for the team to work with him. The lack of trust between him and the other traders was corrosive and ultimately insuperable. And that his distrust of the other traders is what he was ultimately dismissed for.
So take us through the grounds of appeal.
Yeah, so there were 7 grounds of appeal, and they were essentially the same in both the EAT before President Chowdhury sitting alone and the Court of Appeal, where they were similarly unsuccessful. And in short, they covered the following areas. Firstly, failure by the ET to properly direct itself as to the applicable law. In particular, it failed to comply with Rule 62 of the ET rules to provide adequate reasons for its decision. Secondly, failure to properly direct itself to look at the composite picture of the disclosures, i.e. it failed to consider the application of Section 43B of the Employment Rights Act 1996 to the communications together. The third ground was a failure to direct itself as to the requirements for a protected disclosure. So in particular, the distinction between information and allegations or queries. Fourthly, failure to consider the insider context of the disclosure of information. Fifthly, failure to properly apply the reasonable belief requirement of section 43B. 6, failure to direct itself as to the public interest. And lastly, ground number 7, that the ET failed in its conclusions on the reason for the dismissal and essentially whether the decision was tainted.
What were the reasons for dismissing the appeal?
So Lord Justice Bean, who gave the unanimous judgment of the court, went through the grounds one by one, as you would expect. So in relation to ground 1, failure by the ET to comply with Rule 62, he said failure by the ET to set out even a brief summary of the relevant law is a breach of Rule 62.5 of the ET rules, but the court did not think it was a profitable discussion to consider whether it is an error of law, nor there has been substantial compliance with the rule. It is an error, but the real question in the court's view is whether the error is material. So although the ET in this case had somewhat unusually failed to set out even sections 43A and 43B and section 103A were a brief summary of the most relevant authorities, it was held that that was not fatal to the reasoning in the case, as it was not really difficult to understand from the ET's judgment why the claimant had lost, and thus it was meek compliant. Ground 2, which you'll recall dealt with aggregation, Lord Justice Bean confirmed what was said by Mr. Justice Slade in the Norbrook Laboratories Limited and Shaw case, and it was common sense, he said, where she had stated an earlier communication can be read together with a later one as embedded in it, rendering a later communication a protected disclosure. Even if taken on their own, they would not fall within section 43B(1)(d). Accordingly, two communications can, taken together, amount to a protected disclosure, but whether they do so is a question of fact. But in the context of this case, he went on to say, the question of whether any combination of the 37 communications should be read together is rather arid, since on the findings of the ET, none of them amounted to a protected disclosure, whether read in isolation or by reference to previous communications. Ground 3, which dealt with a distinction between information and allegations or queries. Lord Justice Bean confirmed what we already knew from the judgment in Kilrain and Wandsworth London Borough Council, that it's erroneous to gloss section 43B(1) of the 1996 Act to create a rigid dichotomy between information on the one hand and allegations on the other. In order for a communication to be a qualifying disclosure, it has to have, and I quote, sufficient factual content and specificity such as is capable of tending to show one of the matters listed in section 1. Whether it does is a matter for the ET's evaluative judgment. But as I say, he was really going over old ground there because we knew that from Kilrain. But what he did say in relation to this case is that, as in the EAT, the Court of Appeal did not consider that the ET was creating a rigid distinction between allegations or queries on the one hand and information on the other. So ground 4 dealt with the alleged failure to consider the insider context of the disclosure of information. Again, Lord Justice Bean confirmed the principle expressed in the earlier case of Karashi, where it was said that many whistleblowers are insiders. That means that they are so much more informed about the goings on of the organisation of which they make complaint than outsiders, and that insight entitles their views to respect. Since the test is their reasonable belief, that must be subject to what a person in their position would reasonably believe to be wrongdoing. Now, he accepted that insider knowledge, in this case, the insider knowledge point mentioned in Karashi worked both ways, and indeed works both ways. So just as someone with experience in the field has information and insight which should be taken into account in his favour, so too he should know better than, say, a layperson who happened to overhear the conversation, whether it does tend to show that something is amiss. Ground 5, you'll recall that it was alleged here the ET failed to properly apply the reasonable belief requirement. And the Court of Appeal said that whilst Mr. Simpson was right to argue that the ET had firstly to decide whether he actually believed he was disclosing information which tended to show a breach, and secondly, if so, whether that belief was reasonable having regard to his expertise, the problem for him was that the ET had found time and again that he fell at the first hurdle. So in other words, they did not accept that he was disclosing information which he actually believed tended to show a breach of regulatory obligations or a legal duty to clients. If the ET had found a genuine belief to that effect, they would have had to consider whether it was reasonable in light of his expertise. But it was open to them to find that his failure to make any explicit report to the compliance department indicated that he did not genuinely and conscientiously believe that there had been such breaches. Ground 6, that dealt with the alleged failure of the ET to direct itself as to public interest. And Lord Justice Bean reminded us that Kilrain was not the only decision of the Court of Appeal in the field of whistleblowing, which had been given since Mr. Simpson's case was before the ET, as the well-known case of Chesterton Global Limited and Nura Hamid had also been decided. And I think it's worth just recalling that in that case of Chesterton, Lord Justice Underhill had made 4 points about the nature of the exercise required by section 43B1, where he said, firstly, the ET has to ask A, whether the worker believed at the time that he was making it that the disclosure was in the public interest, and B, whether if so, that belief was reasonable. Secondly, the ET must recognise that there may be more than one reasonable view as to whether a particular disclosure was in the public interest. Thirdly, the necessary belief is simply that the disclosure is in the public interest. The particular reasons why the worker believes that to be so are not of the essence. And fourthly, whilst the worker must have genuine and reasonable belief that the disclosure is in the public interest, that does not have to be his or her predominant motive in making it. However, Lord Justice Bean went on to say that the ET had repeatedly found that the claimant in this case, Mr. Simpson, that his real complaint was about being deprived of the commission, which he thought was rightfully his. If the ET had accepted that the disclosures, or at least some of them, constituted information which in the actual and reasonable belief of Mr. Simpson tended to show malpractice, then the public interest test would no doubt have been quite easily satisfied. But that's not what happened in that case. And then lastly, ground 7, that dealt with the reason for the dismissal. And the Court of Appeal said that despite the Supreme Court case of Royal Mail and Duty, and the ET's duty to penetrate through any invented reason to conceal a hidden reason for dismissal, i.e. where a decision maker has been manipulated, for instance, and ascertain the real reason, in this case it made no difference, as the ET had accepted that the decision maker's reasons for dismissing Mr. Simpson were genuine. So that went through all of those 7 grounds of appeal. And Kath, I think you're going to talk to us next about the Independent Workers' Union of Great Britain case.
Yes, that's right. This was a High Court judgment in a judicial review brought by the Independent Workers' Union of Great Britain, which I'll refer to as a union, against the Secretaries of State for Work and Pensions and the Business Energy, which arose out of the COVID-19 pandemic, and from evidence from the union that gig economy workers weren't being provided with personal protective equipment. The union had apparently received multiple requests for help from its member couriers and drivers and other members of the gig economy, raising issues such as the lack of PPE, failure to implement social distancing during deliveries, provision of sanitising and cleaning products, and failure to package COVID-19 samples correctly.
Right, so what were the legal questions involved in the case?
Well, the union sought a declaration that the UK had failed properly to transpose the EU Framework Directive and the EU PPE Directive into domestic law. The union claimed that the directives required EU member states to confer health and safety protections on only protected employees. The defendants argued that the concept of worker in the Framework Directive corresponded with the concept of employee under domestic law. But alternatively, they said the protections conferred on workers under domestic law were sufficient to transpose the directives.
So what did the High Court decide in the case?
The High Court held that the protection under the directives extends to Limb B workers in domestic law. In other words, those who fall within the definition of worker in section 233B of the Employment Rights Act 1996. In other words, those who work under a contract other than a contract of employment, whereby the individual undertakes to do or perform personally any work or services for another party to the contract whose status is not, by virtue of the contract, that of a client or customer of any professional business undertaking carried on by the individual. The court held that the general health and safety obligations in the Framework Directive were properly implemented by Section 3 of the Health and Safety at Work Act 1974, which requires employers to conduct their undertakings so that other persons, including workers, are not exposed to risks to their health and safety. The court also held that the obligation to ensure workers could take appropriate steps to avoid danger were properly transposed through the Management of Health and Safety Regulations 1999. But the court held that there were no equivalent domestic protections for workers not to be disadvantaged for taking steps in response to danger, nor were there equivalent obligations on employers in respect of PPE.
Right, so what do you think the implications of the decision are then?
Well, its effect is to extend health and safety protection to workers, which is a substantial section of the workforce, including those in the gig economy. So it's a decision of great significance, particularly so given the context of the COVID-19 pandemic, where we can recognise there has been a lot of reliance placed on the services provided by gig economy workers in many areas. And of course, given the context of the risks posed to the health and safety of such workers by the conditions of the pandemic. So what's the final case you're going to tell us about, Craig?
So the final case I want to speak about is called Miron. There are two respondents, Adecco UK Limited and secondly Whitman Laboratories Limited. It's a judgment handed down by the EAT on the 4th of December of this year following a Rule 310 hearing. It involved appeals against case management decisions taken by Employment Judge Dawson, sitting in the ET at Southampton, and by the REJ for the Southwest Region Judge Pirani. So those decisions were made in relation to an ongoing claim made by the Romanian claimant against both respondents, which included claims for their dismissal and unlawful sex and race discrimination, the facts of which needn't concern us for the purpose of this update. But the claimant also appealed against Judge Dawson's refusal to recuse himself from dealing with the case on the ground of alleged apparent bias.
How did the claimant frame his alleged apparent bias appeal?
From the claimant's skeleton argument, the EAT judge identified 9 allegations of apparent bias against Judge Dawson, which included not giving adequate reasons for his case management decisions, giving an amused look towards and exchanging complicit looks with one of the respondents' representatives, showing disinterest in hearing the claimant's arguments, failing to address a bad faith allegation made against one of the respondents, the limits the judge had placed on the size of the trial bundle and on the length of witness statements, which he claimed were unfair, and that's the point I'll come back to. Failing to take an active role in the management of the case and to protect the claimant's interests as an unrepresented party, and not enabling the effective interpretation of proceedings into Romanian, and finally being involved in private communications with one of the respondents' legal team.
So what was the outcome?
Well, ultimately, the EAT was satisfied that there was no reasonably arguable case of apparent bias. Judge Dawson's conclusion that he should not recuse himself from further involvement in the case on the ground of bias was correct. And very detailed and thorough 49-page judgment handed down by the Deputy High Court judge who dealt with the case. There is a very useful exposition of the legal principles applicable to applications which are made for judges to recuse themselves on the ground of alleged bias. But to my mind, at least, more significantly, so far as the day-to-day case management of trials and employment tribunals is concerned, is the reasoning given in the judgment for the determination of the issue of length of witness statements and sizes of trial bundles. And I think in particular, it's worth noting from the EAT judgment, paragraph 43G, in which the judge said the limits set by the judge on the size of the bundle, which is 350 pages, and on the length of the witness statements, 5,000 words, increased in the case of the claim words, are not indicative of bias. Such limitations are not infrequently imposed by way of case management order. A fair-minded and informed observer would regard these as entirely legitimate case management decisions. And the second paragraph I point out would be paragraph 64, in which the judge said, I reject as wholly unarguable the claimant's proposition that limitations on the size of the bundles and witness statements are antithetical to the right to a fair trial. Indeed, by focusing the minds of the parties on the relevant issues and evidence, such limits may serve to ensure the fairness of a hearing.
Do you think this is a good thing, Craig? What do you think the wider implications are?
I do think it's a good thing. In my experience, the relation of length of witness statements and size of bundles has been commonplace in the Southwest for quite some time now. And I think following this judgment, I think we're highly likely to see other regions adopting the same approach from now on, particularly when tribunal time is so precious. There is a huge backlog in cases, as we all know, in the system, and the general need to manage claims as efficiently as possible, whilst at the same time ensuring compliance with the overriding objective of dealing with cases fairly and justly. And just, I think, finally, I should add that it seems to me this case follows an apparent, relatively recent trend of the EAT to give litigants, practitioners and judges helpful procedural and practical guidance of how to prepare and manage cases, because you'll doubtless recall Her Honour Judge Tucker's observations in C and D that parties should avoid using a narrative style in their ET1, ET3, as well as more recently his Judge Taylor's guidance on the correct procedure to adopt when considering applications to amend tribunal pleadings in the case of Vaughan and modality partnership.
Thank you very much, Craig. And I'd like to thank everybody who's listening to our case law update. That concludes it, and I'd like to wish everybody a very Merry Christmas and a Happy New Year. We hope to see people in person in 2021. Goodbye.
Bye-bye.